We are back in session. Thank you all for accommodating us with a recess. And I need to introduce another member of our panel for this morning. It's Judge Tim Easter. He's from Franklin, Tennessee. He's joining us in the place of Judge Ayers, just for this argument, though. So, Madam Clerk, you may call the next case.
State of Tennessee versus Christopher C. White.
Good morning.
Good morning.
Court, Mark Scruggs of the Nashville Bar representing the appellant Christopher White in this case. Just to get started with the case, if you've ever built your own home, you will probably relate to what goes on in this particular case, and it will also help you in your understanding of some of the terminology that goes on here. I would respectfully submit that this is a very important case for the future, since I have seen that in many district attorneys' offices, at least in Middle Tennessee, those offices are seeking criminal sanctions against contractors, subcontractors.
I'm sorry, can you say your name again, sir?
Mark Scruggs.
Mr. Scruggs, rebuttal time.
Oh, I'm sorry. 2 minutes. How about that?
2 minutes?
2 minutes.
It's whatever you like. I just want to be mindful, and she needs to kind of keep us on track.
Okay. Sorry
Go
about
ahead.
that.
No. I just want to.
Carried away there.
No, that's fine.
Anyway, what's important about this case is what you have here is what I call the fusion of contract law and criminal law.
Is that a thing?
Well, that is clearly a thing here, is what it is. And in this particular case, it was the failure of the trial judge to recognize the applicable contract law and the written contracts that were in place and in effect between the parties as controlling.
What was charged, or what ultimately went to this trial judge in the bench trial, was a straight theft.
It was a straight theft indeed.
Correct? Okay, so when you say all of these contract principles and his failure to recognize the contract principles, can you put that in the context of the theft?
Absolutely. Okay, so what we have here is, with regard to the remaining count, as you probably are aware from reading this, the state had indicted my client on a home improvement fraud statute count, Class A felony under 39-14-154. I waited till trial for purposes of double jeopardy to bring up the fact that the state had indicted my client on a statute that did not apply to him, and that sort of set the tone for the rest of the case. The rest of the case, the tone was simply, was there a theft that had occurred? Right. And under TCA 39-14-103, there are basically three elements that you have to address. Did the defendant knowingly obtain control over the customer's property? Whether he did or did not have the owner's effective consent over that property? And then did he intend to deprive the owner of the property? Okay, and I cited the State versus Ammons case, which is a very, very on-point case here. And what you have is you have to integrate the contract language, the contract provisions, in order to make those determinations. I would respectfully submit that, in essence, this case should have been decided on the first 5 or 6 exhibits. The first exhibit was the contract.
All right, so inherent in a contract is who the parties are. So if you could help me, who was Countrywide in this case?
Countrywide is a company owned by the defendant, Christopher White. Right. And the court made a ruling that since he was the owner of the company, that he could be charged criminally for the actions of that company. Okay,
and who was Majestic Builders?
Majestic Builders was another company owned by Mr. White that had nothing to do with this particular case.
Okay. All right, so those are the parties, at least Countrywide, to the contract. So
yes.
We're talking about the defendant here.
Yes.
Okay. All right.
And that's where all these transactions arose from. And as I said, if you can simply compare the exhibits, the first 6 exhibits, you'll see where Exhibit 1, the contract, on page 3 of that contract, it sets out the draw schedule, the payment schedule, and then you're going to see in the next 4 or 5 exhibits some change orders, all right? And then Exhibit 2 that was introduced is the customer balance detail. It shows the payments that were made during the course of the construction, okay? So what we had here basically, Judge, was a breach of contract case that turned into a criminal theft case. And with all due respect to the lower court, and even the state in its brief, does not even address the rights and the duties of the respective parties that were involved.
Okay, so the trial court in this case, serving as the trier of fact as well.
Yes.
Said that there was consent by deception, and that is, consent by the homeowner through deception. That's what was in his order. Are you unfamiliar?
I know that's what he said. I don't know where he got that from.
Well, I was going to ask you that. I mean, I was going to ask you what was that. I was looking for the deception. We're talking about a criminal offense. So your issues are, number one, subject matter jurisdiction. Will you agree with me that the trial court had subject matter jurisdiction as charged in this case?
Well, yes, for a theft
Okay, so
case, yes.
we don't have to deal with
Right.
that first issue.
And I may have conflated that somewhat.
Okay, thank you.
Okay.
Number two, and we'll get to the state's brief
Yeah.
here just a second, but the trial court seemed to be attempting to distinguish Ammons,
Right.
okay, by saying that there was deception on behalf of the, I guess your client, the builder.
The builder, right.
And so I was trying to see what that was.
Well, there was no deception. The paperwork clearly shows that my client, his company, proceeded with the construction of the home in accordance with the contract. In fact, the fact that they did it in about 10 months is pretty remarkable anyway in this day and age. But nevertheless, when they get to that fourth draw in August of 2015, at that point in time, that fourth large draw is supposed to be addressing the finishing the rough ends and the insulation and some of the interior work. And when the customer, Ms. Monk, decides to short them on that, pursuant to the contract, my clients can walk off the job, declare a breach, and she would be liable for all outstanding cost of labor and materials under the contract.
Yeah, I'm not familiar with you much, Mr. Scruggs, so I'm going to let you know that I haven't seen you argue before us. What we do in terms of getting into the record, we do a preliminary. We don't do a deep dive. So can you tell me what led to the, I guess the homeowner not paying? Was there some sort of work that wasn't being done in terms of the facts of this case?
No, ma'am.
Okay, so I'm trying to figure out what happened, where the breakdown
I can
occurred.
tell you what it was. Basically, it's this particular homeowner decided to build this house with cash as opposed to getting a construction loan. And the way in which she was building it, there were change orders that required extra costs. For example, right off the bat, she goes out to the site, sees the subcontractor excavating the area, and says she wants a basement. Okay, so that's an extra cost. They have to dig deeper, all right? They have to do the walls, all the things associated with a basement. And as a result of that, she can't get her garage. The original contract called for a garage for about $21,000, but then if you wanted a basement, it's gonna be about $31,000, $32,000 extra, okay? And then as time progresses, there are other things that are added to it. This is not unusual when you build a house. I mean, if you've ever built a house, what happens is that the homeowner will change their mind, and that's why you have change orders, and there are change orders in here that show all this. Now, this particular customer was very, very involved in going out to the site and questioning what was happening and so forth, and there were some issues that occurred early on.
And that's what I was going to ask you about. It sounded like, from reading from some of the comments made by the trial judge in his ruling, and at his ruling on the granting of the Rule 29 judgment of acquittal on count 1, that there were some concerns about the shoddiness of the work.
Right.
And that seemed to be driving the trial judge. It seemed to, anyway, that's where the issue was the quality of the work, perhaps, was an issue. Am I correct about that?
Yes, sir, and this is a very touchy point because after count 1 was dismissed, the trial judge and the DA said the quality of the work is irrelevant now But we kept talking about it the rest of the time, and I think that that is relevant even to theft, because did you get what you paid for? Okay, that's a major issue, and that's why I kept coming back, and I introduced the building codes personnel, their inspections, to show that it passed all the inspections required by August of 2015, including the framing inspection. And a framing inspection, when you pass a framing inspection, that's a big deal right there.
That's where he said it was dried in. Is that
Well,
right?
okay, let me just say that there's a distinction between the two, okay?
Well, I'm going to learn a lot about, I'm sure from reading this record. My dad was a contractor, and there's a reason I went to law school.
Okay.
But if we can boil this down, the theft, okay, the $10,400 amount, that's the money, the $3,400 owed to the insulation company, right?
Right.
And the $7,000 and change Precision Plumbing. Is
Right.
that, were those the?
That's what the judge said, yes.
Okay, so the victim, Miss Monk or Miss Bear, paid the insulation company out of her pocket, right?
That is correct. That's what she
Okay.
testified to.
And then the plumber testified that he sought, through letter and seeking payment from Countrywide, and they never paid at all, so the plumber never got paid.
Plumber never filed a lien, nor did he get paid. So Ms. Monk was not out of pocket any money with regard to the plumber.
All right, so that is the money that the trial court found formed the basis of the theft.
Right.
Okay. Please try to limit why you believe those two amounts don't constitute the theft charge.
Okay, first off, the court has to do an analysis of the contracts to determine whether or not Ms. Bear/Monk had the right to dictate which subcontractors got paid and when. I would submit that she did not have that right under the contract. Number two, even if she did have that right under the contract, when that fourth large installment of $57,000 and some change came through, when she was billed with that on August 13th of 2015, she shorted them $12,000, okay? So that could explain not paying those particular subcontractors. But let me just say this about that. That's somewhat deceptive because we're not clear on when those bills came in, whether they came in September or October or November. The point is that the relationship had deteriorated beginning in August of 15 through October of 15, such that my client was performing all this extra work for which he never got paid. And I can list it to you as well. And then you think in terms of contract law, you think in terms of set off and so forth, such as things that he did do, all right? He installed the drywall.
Right,
He
but
did the
if your
trim.
math is right, if he got shorted $13,000, he might have lost $2,000, but really he shorted his subcontractors as well as the victim. If the math is right, correct?
Oh, on the 45, where she paid 45 rather than the 57?
That's right.
Right. I will say this then. He did not pay those persons, okay? He chose not to pay those persons, but he did not pay those persons because under the contract, she was liable to pay those persons.
Well, one of them put a lien on her house that she had to deal with, right?
That's the way it always works. Ultimately, the subcontractor will put a lien on the house, and then it comes down to who is responsible. And under the contract, and I can read it to you, the section.
Well, we'll read it, but
Okay.
the way it always works, well, the plumber, for some reason, he chose not to file a lien on the lady's house.
Right.
Okay. So it doesn't always work that way.
Well, Mr. Scruggs, in count 2 of this indictment, the theft, is the plumber or those persons that you refer, are they listed as the victim? Or
No,
is the
they're
only
not.
victim in this is Ms. Monk?
Right. So she never had to pay for the plumber. So she's not the victim. It would be the plumber who would be the victim on that.
Okay.
And again, I know there's a reluctance in my practice in dealing with criminal court judges and reluctance of them to look at these contract issues as complex as they are. That's why I attached,
Well, from what I hear you saying,
Yeah.
it sounds like you think this is a civil matter.
there's no question this is
Or-
a civil matter.
Criminal judges are just not equipped to handle
I don't want to
contract
say
cases?
things like that.
It
I don't
sounds like
know.
that's what you said.
Because there's
Mr.
plenty of
Scruggs.
criminal judges that also do civil work as
Well,
well.
you've known me in a former life, and I would
Yes.
swap hats every day.
Right.
And I've got a question for the state on this case.
Yeah.
I really do,
Well,
as a civil judge.
Yeah, I just, the thing about it is that I kept harping on this. Please read the contract. Did Ms. Monk even have the right to dictate where her money went? Okay, she did not. She did not have the right to short them that $12,000, all right? And at the very least, look at the contracts, and we can sit here and talk about the contracts all day long. But I'm getting back, I know you don't want to do that. I'm about done. I just get back to, I'm finding this is happening in other counties now, okay? And I think that the law, at least the home improvement and the contractor's fraud statute, it was designed to catch people who were scamming others, okay? The scam artist. You know what I'm talking about, the driveway scam or the roofing scam and stuff like that. That's what it's for. These cases here involving complex contractual issues have no place in the criminal court. And that gets back to intent, okay?
Mr. Scruggs, yeah, before you start to wind down, and I promise I'll give you your time, I'm very interested in understanding your issues, and you've already conceded we don't have to spend any time on your first issue. The meat of your appeal is in your second issue. Your third issue deals with collateral, estoppel, bankruptcy. Can we agree that
Yeah.
that's, okay?
Well, I threw that in just for your consideration.
I just want
Yeah.
to know where you stand on those, where we need to dedicate our time in this
Right,
case.
it definitely would be with sufficiency of the evidence and interpretation of the contract as it relates to the elements of theft. And I think the last one, the intent, and that's what in Ammons the court got to. There's no evidence that my client intended to defraud anyone or intended to take her money. In fact, she got a house that she really still owes him money for, and it's worth twice as much as what she paid for it.
Thank you, Mr. Scruggs.
Good morning. May it please the court. Ben Ball on behalf of the state. Here, the evidence is sufficient to support the defendant's conviction for theft. I'm uniquely aware that theft cases involving contracts are fraud cases.
But you know what my question is for you? I think didn't you argue the Pardue case, the homeowner fraud, the home improvement fraud case? Didn't you argue that a few months ago?
I was here for that. I don't
Okay.
believe that was.
Why is this not a civil matter? That's my question. Why is this not a civil matter?
That is an excellent question, and it is not a civil matter because it's ultimately not about the contract here. A breach of contract is not what's being punished.
Well,
What's
what I
being-
found unique, Mr. Ball, and you're senior counsel or you're high up in the AG's office, so I've read a lot of your briefs. And your brief in this case, if we distill it down to what the sufficiency of this is a sufficiency of the evidence case, basically. And there was no facts attributable to the trier of fact establishing the deception aspect, for the consent element of theft. And so that is what I was trying to get from opposing counsel, Mr. Scruggs. What did the trial court hang its hat on was the reason for the deception or the fraud in this case? I couldn't find it. I looked in his order. He cited a bunch of cases, all relevant cases, but there was no facts supporting even in its order. There were no facts supporting that element. So help me out there.
First off, apologies if my brief was not specific enough on that point. What we have here is a swearing match, ultimately. We have the victim who testifies and the defendant who testifies, and they differ on the point of subcontractor payment. And we have the victim accredited, and the defendant is not accredited here.
Where's the proof? If I'm writing this case, you know how we operate. I've got to have facts supporting the facts most favorable to the state. Each element of the offense. So point to me the elements supporting the fraud here.
So what we have is that we have the victim who testifies, and we have, of course, the contract itself, which indicates that this is sort of a prepayment installation situation where she's going to pay and then they're going to do the work, including getting the subcontractors. She testified that she was paid up, and then these contractors were hired and not paid. Now the defendant testified, acknowledging that they should not have been contracted if she had not been paid off, and he claimed that he made an exception to keep her happy. What we also have is we have emails between the two where his emails with her don't correspond with what he is telling the court. He tells her, look, you don't owe anything, we're good, we're going to take care of you. And he's essentially shining her on. And what this indicates is that when he took this money, he had no intention of paying these contractors. So he took it.
So the emails, I mean, because again, your brief, nothing. You want us to look at the emails where he says that he is going to provide customer service and take care of her.
He says more than that, Your Honor. I mean, he essentially says, you're not on the hook right now. And then he testifies otherwise. And now he says, oh, no, she was on the hook. It's about this missed payment. That's not what he told her. And the court had the opportunity to look at her testimony, to look at his testimony, and determine who the court thought was telling the truth.
Well, it's not a credibility contest if we're talking about, if we are looking at a fact. So that's what and so you're talking about the emails. So it's a matter of believing conflicting emails, and that was the intent to defraud? Is that what you're saying?
That goes to intent to fraud, as does their testimonies, which don't line up.
On what?
On the issue of the contractor, the subcontractor payment. And okay. She is told, look, everything's caught up, and the contract says, we're not going to hire any subcontractors until the prepayment's in. And then she gets this sort of shined on in this email. No, you're fine. We're going to make everything right. And then he hires subcontractors that from his testimony, from the emails, and from the circumstantial evidence here, the trial court determined, as the trier of fact, that he had no intention of paying.
Okay, so under our standard of review, she was credited, but are the defendant's emails the state's proof of the deception, the false impression? Is that?
That is certainly part of it. I think that his own testimony and its conflict with the victims as well. But I think the emails are really solid proof of this. The deception, and then his overall evidence, his intent.
Okay, what does the proof of changing the business name and changing the locks out, does that go to any of the elements?
I think that goes towards his intent as far as whether he ever intended to pay the contractors. There was testimony that subcontractors were coming by the office regularly to seek payment that they weren't receiving, that the locks were changed, the business, and the name was changed from Countrywide to Majestic. That's certainly circumstantial evidence of that as well.
But that's really not an issue here, whether or not he was going to pay the contractors, correct?
Your Honor, it is an issue. The state need to show that the property was obtained through deception and intended to deprive the victim of the money. And so he took the money under false pretenses. This money is going to go and pay the subcontractors, and it did not. And that is theft. I realize there's a contract here, but this is not a simple case. This is a fairly, I shouldn't say simple, but this is a straightforward theft case.
How does her failure to pay the $12,000 or $13,000 play into this?
Your Honor, I don't think it does. I think that would go into the charge that was ultimately dismissed. This is not about the shoddy construction. There was shoddy construction, but that's not what it is about. This is about, as Your Honor noted, this little over $10,000 that was not paid to the installation company and the plumbing company.
Mr. Ball, you would agree with me that MON stands for the proposition that contracts don't belong in criminal cases.
I agree, and this is not about the contract. The contract is certainly relevant, but this is,
Every other case, even the cases cited in your brief, which on the law is beautiful as usual, but those cases, you had a clear intent, even by circumstantial evidence. Somebody takes an individual's money and goes gambling with it. Somebody takes an individual's money and they never even respond back to the individual. I mean, there are other examples of where we've dealt with that sort of situation. I'm having a real tough time seeing that here. Can you help me?
Your Honor, I would say the proof of intent is almost always circumstantial. I mean, we're not going to get a statement somewhere, hidden away where the defendant says that it is my intent to deprive them of this money. But from the actions here and from his own statements, which were discredited, the victim's own statements, I think we can suss out that there was never any intent here to pay these subcontractors, despite his assertion to the victim otherwise.
So your theory is then that he was stealing her money?
Absolutely, this is a theft case, and he stole her money. The contract is certainly relevant, it informs the facts here, but this is not about a breach of contract. This is not a breach of contract being pursued as a theft. This is a theft, and there happened to be a contract which informs the situation.
Which says, I will give you, Mr. Defendant, money. I will give you this money. So it's not like he was coming in the middle of the night and breaking into her safe and stealing her money. She gave him the money pursuant to the contract.
Right, and the contract and the defendant also says to her, and that money will be used to pay subcontractors. You're paying this in advance. You're not going to be left on the hook with these subcontractors. You're not going to have subcontractors showing up, asking you for this money, putting liens on the house. Yeah. So that's the deception.
It really does smell like a civil matter to me, and I will certainly look at the record with my colleagues here, but it just smells like a civil matter as opposed to a criminal. But
Your Honor, I would suggest to you that there's a civil matter present here, but this is not about the civil matter ultimately, and just the presence of a contract does not preclude the possibility of a theft.
If we agree with you, we would be sending a real, would we not, a chilling message to people who are in business when they enter in contracts and may not or have a dispute. If we agree with you, that means everybody should be on notice that if you end up with a dispute, a contract dispute with an individual, there's a potential that you can go to jail. And that's really what Amans was talking about. We're not in the business of creating debtors' prisons or things like that. When a contract dispute arises, we're not going to send people to jail for failure to go in with the contract. That's what the civil courts are for. So I just want you to speak to the effect that if we agree with you, it would have, because I don't know any other case that has gone the state's way on an issue like this that isn't more explicit with the intent to deceive or the deception, defrauding piece.
Your Honor, I understand the concern, but I don't think this case would send that message. I think the message it sends would be, don't steal from your clients. This is not just about a contractual dispute. There is a contractual dispute present, but this is about the theft, and I think this court can confine it to that. I certainly understand the court's reticence to wade into these situations where there are complex contracts and whatnot. But the simple existence of a contract should not protect a defendant who commits a theft.
But the trial court didn't even get into the specifics of the contract.
Because this is about the theft, and the court focused on the representations to the victim about the payment of contractors. In fact, they hadn't been paid, and accredited her testimony and did not accredit the defendants.
Sort of to piggyback on something that Judge McMullen just brought up about the message this would send, aren't there remedies available, or I should say probably not available, to a defendant who's charged criminally that if it was a civil judgment, he or she could otherwise discharge, let's say in bankruptcy. But if it's a criminal conviction that involves something like theft, those are non-dischargeable. And to me, I'm just wondering out loud, does that send a message then to the legal world, hey, if you've got a client who's in business and has a contract dispute, the better way to go is criminal? I just bring that up.
To that, I would say that if this were a case where someone was being punished simply because they breached a contract, that would be a concern. That's not what's happening here. This is someone who had a contract with someone, but also committed theft. So, there are a lot of things bubbling around the periphery of this. There are certainly contractual disputes present. But this is not a situation where you have a homeowner who's simply dissatisfied with the work done on her home and has turned to the criminal justice system for remedy instead of the civil system. That's not what we have here.
So looking at the theft statute, looking at the elements, the third, I guess it could be the first and the third, but exercising control over the property, and then the third, intent to deprive the owner of the property. All right. What Judge Easter asked you earlier about shorting the subcontractors not really being at issue because the victim, Ms. Bear, is the victim here. Is there a difference between the $3,400 that she ultimately had to pay and the $7,000 that I guess Precision Plumbing absorbed and she was never out?
I don't think the end result of what happened matters in this. The question is whether the money was taken from her and put into his control through deception. It was, and whether he intended to deprive her of that money, and he did.
Value matters, Mr. Ball. I think is that not what you're asking?
Yeah, but the values matters, of course, but the circumstances are slightly different between what happened between the insulation company and the plumbing company as to how it affected the victim, right?
Absolutely. The consequences were obviously worse when she undertook to pay that, but I think that by the time she does that, the theft has already occurred. The defendant has taken the money under false pretenses with no intent, with the intent to deprive her of that money, that she sought to make it right with one of the subcontractors. I don't think ultimately changes that analysis.
I noticed, I remember reading in one of the briefs, you got 4 years probation. Did that include restitution? So the amount does matter then, I suppose.
We don't do that here. Yeah. Go ahead, Mr. Ball.
I didn't see it in the briefs anyway, whether or not restitution was part of the probation. So.
I believe that the sentence here has not been challenged, and obviously the amounts matter because they determine what grade of theft this is. So the question is, what amount of money was taken from her under false pretenses with the intent to deprive her of it? And that was the money that did not go to the contractors and was kept by the defendant. We don't know what he did with it. We don't know if he gambled with it or any of those things. That ultimately doesn't matter. So I understand that this has I'm sure what the court would refer to as the stink of a contract about it. This is not a contract case. This is a theft case, and I urge this court to find that and affirm the judgment of the trial court.
Thank you, Mr. Ball.
Thank you, Your Honors.
Mr. Scruggs, you have another opportunity, 2 minutes.
Sorry. Just to respond real quick. Again, the state's argument is scary, to say the least. And he does not want you to look at the contracts. I would respectfully submit the contracts are critical when it comes to making your deception here. 99.999% of contract breach cases involve money, okay? Whenever you have one of those, it's almost always involving some kind of money. It could be specific performance, but it usually involves money. And that's what this was about. Remember, she shorted them $12,000 on that last big draw that she was supposed to put up, all right? And the fact that they went ahead with work to make her happy, in other words, to get the job finished, even though they didn't get paid for the work, if that doesn't negate intent to deceive or intent to take her money, then I don't know what does, because they lost money on this case, on this contract. So I would submit to you that, and lastly, I would just say that the state wants to say this is not about shoddy construction, but then they say it's shoddy construction. There's a DVD that's in the record here that we submitted to the court in a pretrial motion that shows exactly the quality of this construction. This is a nice house. Granted, there were some issues that had to be addressed, but those issues were in fact addressed and fixed.
Thank you, Mr. Scruggs.
Thank you.
The case will be taken under advisement. We're going to take about a 5-minute recess, and we'll be back out.